Good evening, Norris Lee, and welcome to our second week in our Torah View on the hot issues. Tonight we discuss uh, the issue of juries. Tonight's topic is entitled, "The Jury is Still Out. Should we entrust the law to laypersons?" Okay, where are we coming from? So the final article in this month's The Critic magazine is by Joshua Rosenberg, QC. He recently authored a book called Enemies of the People: How Judges Shape Society. Now, it's more relevant than ever. I mean, he published this a number of months ago, but this weekend, the United States Senate is going to attempt to drive through the nomination and appointment of Amy Coney Barrett to replace Ruth Bader Ginsburg, alaiha shalom, on the Supreme Court, which would produce a Supreme Court that is weighted 6-3 in favor of conservative judges. So, begs a lot of questions here about appointment of judges, about who is doing the judges. Now, the topic of Joshua Rosenberg's article in The Critic is the question of the necessity of juries. Due to Corona, he explains, everything is backed up. You have defendants now in custody who have been there for 8 months. You have those on bail who might not see trial at best until 2022. So do we really need the cost and hassle of juries? What does trial by jury actually accomplish? So tonight, in terms of the Torah view, I'd like to pose 2 questions. Question number 1, what is the Torah's view of juries generally? Is it 1, good, bad, or indifferent? And question number 2, let's say you are called for jury duty. Is it permissible halachically to serve on a jury? Let's talk about the history of juries. Now, it goes back centuries before the Magna Carta, but it was enshrined in the year 1215 in Article 39 of the Articles of the Barons in the Magna Carta. So if you look into your source sheets, I posted the source sheet in the various groups. You'll read the first one says, so the 2 parts of Article 39 that enshrines jury, the notion of juries into law. Those who have been outside the forest are not to come before the forest justices on the grounds of common summonses unless they are involved in pleadings or pledges. And the evil customs of forests and foresters, of warrens and sheriffs and rivers are to be put right by 12 knights of each county, who should be chosen by the good men of that county. I said the first thing I want you to note is who is doing the appointment of these jurors, the good men of the county. Next paragraph. No free man shall be taken and or imprisoned, or deceased, or outlawed, or exiled, or in any way destroyed, nor will we go upon him, nor will we send upon him, except by the lawful judgment of his peers, and or by the law of the land. I want you to remember that concept, judgment by his peers. That is the basis of a jury that is deciding the law. And we'll get to a little later whether that is an idea that Judaism holds of. I'm going to come back to a little later, but what I have there in brackets does not come from the Magna Carta. It comes from the United States Constitution, and it's a little different the way it's described and prescribed in the United States Constitution about juries. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. No mention of jury who are peers. Right? This is a popular notion, but it does not appear in the US Constitution. It only appears in the Magna Carta. So this is the history prior to the enshrining of juries as law or as common practice in the Magna Carta. What would happen? or you had the king that would decide the law, and sometimes it was fair, sometimes it wasn't fair, or you had priests that would decide the law. How would they decide the law? It would be trial by ordeal, which is very simple. If you have someone that's suspected of criminal activity, well, then you allow God to demonstrate whether this person is innocent or guilty. You could try dunking him in the river. If he drowns, then it must be that God decided that this person was guilty. If he survives, then God decided that this person was innocent, and various other ordeals in order to test and allow God to make the decision. So that was the priestly way of deciding the fate of someone who had allegedly committed a crime. Now, to the extent that even once it was enshrined in the Magna Carta that there should be a trial by jury, priests were not allowed to take part. The clergy viewed this as off limits because it was going against the notion of trial by ordeal. So this was a Christian concept, not a Jewish concept, but we see that the idea of trial has long religious roots and religious debates, and we're going to see soon what Judaism's take on it. Now, once we have it enshrined in the Magna Carta, we begin to see the notion of a separation of powers between the executive, the king's power, the parliamentary power, the power of the judiciary. Now, the source for the 12 jurors is a little unclear. Some associate it with Jesus's disciples, the apostles, the 12 apostles, hence the ability to be able to take the law, even though it doesn't make a lot of sense considering the law was something that was given over to the Old Testament. The New Testament was God's grace. The second idea is that 12 represents the zodiac, the months. That way, everyone could be covered and judged favorably, judged accordingly, because there's something in each of the jurors that attaches itself to the person being judged. All right, so let's begin with the question from Judaism's perspective. You get summoned to sit on a jury? Are you allowed to serve on a jury as far as halakha is concerned? So we look at the Mishnah halachas. You remember from last week is Rabbi Menashe Klein, the Ungvara Rav, who was a Holocaust survivor, then moved to Williamsburg and later to Israel. Says the Mishnah halachas. I haven't translated this directly, but I will translate it now. It is forbidden for a Jewish person, according to Rav Menashe Klein, to participate as a juror. That was the question. Or to act as a judge in non-Jewish trials. Moshe Emes, because this is what's written in our Holy Torah that was given to Moshe on Mount Sinai in Parshas Mishpatim. It says, and these are the laws that you shall place before them. Right, that's God speaking to Moshe. These are the laws you should place before them, the Jewish people, the nation of Israel. Tanya B'Gemara Gittin Daf Pechas Amud Beis, and the Talmud says, Rabbi Tarfon would say, "Kol makom she'ata motzei agrius shel ovdei kacham, af al pi she'tneim kedin Yisrael, ata rashai lizakek lahem." Anytime you have non-Jewish courts, even though they may have the same laws and they may pass the same judgments as a Jewish court would, one may not use them for one's legal purposes. As it says, and these are the laws you should place before them and not before idolaters. So Rabbi Klein gives a long responsum, but the first part is really dealing with monetary matters. How about when it comes to issues of capital punishment? And this is something also very relevant to the upcoming US elections, questions of differences between conservatives and liberals and who is deciding the future of the court. It seems to be that the willingness to execute capital punishment, particularly in America, is something that conservatives carry that banner, whereas liberals would say not. Now, the Jewish perspective is, even if you have Jewish conservatives, we are really reticent about the whole capital punishment thing. And we see Rabbi Klein, who mentions this here. How does this work? He says like this. But up until now, generally, I'm talking about monetary matters, civil cases. If a person was summoned for a case, to be a judge or a juror in a capital case, it's even graver. Why? And if we're talking about someone who's Jewish, you certainly can't rule the law that they should be killed, and you have to do everything within your power to avoid attending such a court case. Because in order to judge capital cases, we need a proper beis din that was ordained one to the next, all the way back to Moses at Mount Sinai, and we don't have any rabbis even today who could serve on such a Sanhedrin. Or beis din shel chavkim v'lo pachas mehem has to be 23 judges, no less. We don't have this during our exile, and even prior to the destruction of the temple, 40 years before, they stopped judging capital cases. And if you would take part in judging a non-Torah judgment of a capital case, you would be essentially murdering this person. Omnom, however, he does say, what about if I know that I am being summoned for jury duty and it's a Jewish person? I'm not sure why, particularly a Jewish person and not a non-Jewish person, why he would say differently if we believe that capital punishment is unacceptable. He says that maybe I should go, because I can save this person's life. Because as the juror, I am not going to agree with the others, and we know, and I'll get to it soon, that in a jury, there needs to be a unanimous decision, and therefore I'm going to, by virtue of being there, save this person's life. It would seem that it's permissible to go and serve on the jury, but adarabah. It's a mitzvah to go and save this person's life. Now, it's unclear, as I say, whether, in which case he's talking about whether you should go or you shouldn't go, but certainly I think that if one would say from the outset that I believe that we have to save this person's life come what may, you would probably be dismissed from serving on that jury. And so there's almost a deception that takes place, but maybe that deception would be permissible, knowing that it would be life-saving. All right, but that's the Rabbi Klein's position about serving on a jury. He's certainly not in favor of serving on a jury. His position is in the minority. Most halakhic authorities would say that one has an obligation to do one's civic duty and serve on a jury as part and parcel of Dina de Malchusa Dina, that the law of the land is the law. And what's more, what we see now in the Rambam is not only is the law of the land law, one of the 7 Noahide laws is that every country, every city, every place needs to have a system of justice. And if we're not going to support that system of justice, how can we expect anyone to abide by that system of justice? So let's see that in Maimonides now, Law of Kings. Adam and Eve were commanded 6 laws. Al-avodah zarah, al-bikas Hashem, not to worship idols, not to blaspheme, not to murder, and not to commit immoral sexual acts, gezel, not to steal, and to establish systems of justice. Even though for us they are a tradition that we received from Sinai, from Moses, and it also makes sense, they're logical. And so once Noah comes out the ark in this week's parsha, we have the addition when they're allowed to eat meat. Prior to the flood, everyone was vegetarian. After the flood, when they're told you're allowed to eat meat, they're told don't eat a limb of a living animal. Nimtzu Sheva Mitzvahs. So in total, there are 7 commandments. And this was the case throughout the world until Abraham came along. Along comes Abraham, and he's also given the mitzvah of having a bris, and then he was the first one to daven the morning service. Yitzchak was the first one to separate tithes and to add mincha. Yaakov added the law against eating the sciatic nerve and the sinews, as well as instituting Mariv. And in Egypt, Amram, the father of Moshe, was given more mitzvahs until Moses came along and the Torah was completed through him. How are Noahides, Gentiles, obligated concerning the laws? They are obligated to establish, to set up judges in every county to judge these 6 mitzvahs. In other words, the 7th mitzvah, the mitzvah of making a system of law, is in order to facilitate to carry justice for the other 6. And they have to also warn the people. Right? So there has to be a system of police and government laws and a system of fair justice, of fair trial. Okay, so there we have it, that we have a law of the land, a law that we not only should abide by, but promulgate. And if we're promulgating it, then many of our sages say that it makes sense that we should show by example. And if the law of the land is to have a jury system, then we should be part of that jury system. Why? Because ordinarily we might say that when it comes to the law of arka'os, when it comes to our own business dealings, for example, that we might go to a beis din, we should go to a beis din to have that adjudicated. But here, it's not my own case. It's a case that the law of the land needs to adjudicate. So it's my civic duty and my Torah duty to fulfill the law of the land, to show up and make sure that the law of the land is fulfilled. Okay, now here's some of the issues we have with the features of a jury, why not everybody's comfortable with the jury. And I revert back now to Rosenberg's article, along with some general comments and notions that seem to be a little problematic when it comes to a trial by jury as opposed to a trial by judge. The first issue is that we have lay persons making the decisions, passing the law. I mean, they're not versed in the law, they're not qualified, they don't know the law. So what gives them the right? Maybe Judaism would say, well, they can't be a dayan. How could they be essentially a dayan, a judge, and judge the case? Because if they don't know anything, they've never learned how to judge the case and decide the law. So what would Judaism say about that? Okay, so first we have the Shulchan Aruch in CM means Choshen Mishpat, the civil area of law, which is the 4th part of the Code of Jewish Law, in chapter 3. It says as follows: Ein beis din pachas megimel. In order to have a beis din, a court of law, a court of Jewish law, you need to have at least 3 people. In other words, we don't have a single individual judge. Chol shlosha nikraim beis din. And any group of 3 are called a beth din. Afilu hedyotos, even laypersons. Right? So you don't need any expertise to serve on a beit din to be called a dayan. However, the EF should less behocha the idea as far as bedinim about e less behocha diada psilad. No, but in brackets he explains, if you've got 3 people judging a case, it's impossible that at least one person doesn't know the law. All right, so we're not talking total lay persons. We're talking about people who should be there, should be sitting adjudicating the case. And amongst those 3, even if they are not totally expert on all of the laws of this particular case, one of them, if they're qualified rabbis, dayanim, at least one of them out of the 3 should know what they're doing. So we're not talking about complete lay persons. We're talking about people who have a basic knowledge of the law. And at the very least, if you have people who have a basic knowledge, at least they know what is a question that needs to be asked and sent on to a higher authority. And if you have such a base, then they can judge people by coercion. They don't need to ask their permission to do so. If a defendant refuses to appear before the court, or if he doesn't want to appear with the plaintiff in his city, so here in the Shulchan Aruch, we're given the concept of zabla. Zabla, often spelled in English Z-A-B-L-A, or in Hebrew Zayin Beis Lamed Aleph, Zayin Bet Lamed Aleph, is an acronym. Ze Borer Lo Echad. Each one chooses one person. So each one chooses one dayan to serve on the Beis Din, and between the two dayanim, they choose a third who is acceptable to both parties. And between the three, we now have a Beis Din that neither side can claim is biased, and that's how the Beis Din happens. Hagar, Kilgama, says the Rama, "V'nirli davka b'dayam she'en kvuim, alam dayam kvuim be'er la yichol lem lo odin lifneim el b'zeber." That's only true if you don't have a fixed Beth Din in the city. But if there is the Beth Din of the city, an individual can't say, well, I don't like the Beth Din of the city. I want to make our own Beth Din. No, there's a fixed Beth Din. You can't just make up your own rules. And this is our custom. And with less than three, it's not considered judgment. Even if they didn't make a mistake, all right, so here's an important caveat. Normally we say you need at least three people. So we have this multitude of people who are deciding the law together. There are two exceptions, however, that the Shulchan Aruch says. Number one, if they accepted upon themselves the rulings, let's say there was just two people, and they said, okay, we accept you as our judges, we don't need three. If they've both accepted it, which is essentially signing an arbitration agreement, then it would be acceptable, and they have to, that agreement is binding. Or number two, if it is a mumcha l'rabim, if somebody is a well-known big expert and they've come to him for adjudication, then that his judgment carries and they can't challenge it. Next, even though strictly speaking, that expert could judge by himself, it is a commandment of the sages, an enactment of the sages, that he should have other people with him. Even though minimum is three, the more people you have on the Beis Din, the more praiseworthy it is, because there is more likelihood that somebody will express an opinion that is contrary. Right? Here we start to see our notion of unanimity that's required of a jury. Why? Because we want to make sure that all of the opinions are expressed and argued out, debated, so that the proper justice is carried out. To the extent 11 people are better than 10 people on the Beis Din. So we're reaching our number of 12 jurors almost. However, one of the differences we have between the Beis Din according to Jewish law versus the concept of a jury is that they all need to be learned people and pious people. It's forbidden to sit on a panel of a Beis Din unless you know who you are going to be sitting alongside. Maybe the other people will be improper. And you're in a band of thieves, not on a Beis Din. And someone who doesn't know his material, even if he has permission to judge, that is unacceptable. And if anyone wants to challenge his ruling, even after the fact, they may do so because he was unqualified to serve. Says the Rambam, and so we had certain times during our history, we had autonomy, even judicial autonomy. And he says that the permission given by the local authority to certain people in the community, powerful people in the community, to be the local judges, even if they might not have been worthy, says the Ramah, Rabbi Moshe Isserles, that it is that doesn't work, that's not halakhically viable. Unless the congregation accepted this individual, then he can judge. And some say that if he is knowledgeable and able to express an opinion and form an opinion based on precedent, then he can judge based given the permission of the local authorities. Because this is included in our notion of the law of the land. Which is part of that is that the country should set up judges. Nevertheless, somebody who does this against the will of the community will eventually have to be answerable before the Almighty. Okay, let us continue. So the next question we have is just returning to our question of capital punishment, because here we have, it seems that in certain places, one should go to a jury one could be summoned for jury duty, and it could be a capital case, like Rabbi Klein says. What's important to note is those who want to suggest that the Torah is pro-capital punishment, we always have to bear in mind that which we were taught in the Mishnah and Marcus at the end of page 3. A Sanhedrin, a high court that killed once in 7 years, that executed once in 7 years, was called a murderous court. Rabbi Lozman Azariah, he says, no, the tradition is once in 70 years. Rabbi Kiva, if we were in the Sanhedrin, we would have made sure that no man would ever have been killed. How? Because we are so careful about checking the testimony, and any slight doubt, we would be able to pull apart the testimony. It would be a hung jury, that it would never have happened. The capital punishment would have occurred. No, you can't have such a general rule, because if people know that that's the rule, then you'll just increase murderers, because people know that they can get away with murder, because you're always going to have Rabbi Akiva and Rabbi Tarfon who are able to dismiss a case. Okay. So let's return to our notion of trial by jury. And I mentioned earlier that there is a difference between the UK and the US in terms of trials by peer. So that's enshrined in the Magna Carta, but it does not appear in the US Constitution. And according to the traditional English law, peers meant people who were noblemen, people who were of a certain status, a certain class in the community. Until a certain point, a century ago, it meant no women, and it meant landowners, and it's taken time for those things to change. That's not always the case, though. If you look back, historical piece of trivia for our community, if you look back into the records of the Jewish Exchequer in England from 1278, it refers to 4 cases involving a Christian and a Jew where mixed Christian-Jewish juries were used. Why? Because that's how they understood the law as enshrined in Magna Carta. There needs to be a jury of peers, and they felt that it wouldn't be fair if it were all Christians. So certainly there was an awareness of anti-Semitism even back in the 13th century in this country, which is really special to know that there were those who were looking out for us then, even though it was really not good times for our people, as we found out not too much later after that. Okay. Now, one difference though, although in this country officially there was jury by peer, but there wasn't in the US. One difference that there is in America versus England is the blue ribbon jury. Blue ribbon jury is a specialist jury that it has this expertise that we're talking about in halacha here, that they know the particulars of a certain area. In fact, in English law, if they would find that someone was a specialist in a certain area, they could be dismissed traditionally from a jury because they might not be fair because they might know too much. So that's one little difference between the UK and the US. And let's see halachically. So we have seen so far that we do need people who have a general basic knowledge in halacha, and the hope that there'll be at least one specialist there who will know how to deal with this particular case. But further to that, on top of page 4, we have if someone is told to stand trial before a judge who is less knowledgeable than him, he can't be forced to stand trial before him. You have to find someone who is on a level that they can judge. This almost is about the jury by peer idea, because to have someone that is less knowledgeable or less expert in the field than the person who is being put on trial is almost an unfair idea. So hence we have this notion of jury by peer. I should also note parenthetically, although this is an Anglo-American idea, jury by peer, it doesn't occur in many countries around the world, including Israel. One of the reasons is that in Israel, there are concerns, and other countries as well, where there are concerns of minority cleavages that would stack the jury against the individual, that we hope will not be the case with judges who are appointed. So say, for example, you had an Arab standing trial, and it was a completely Jewish jury, and it was an Arab against a Jew, and it could go in a certain way just based on ethnicity. And those who wrote the laws in Israel felt that that would be inappropriate, and therefore they've decided to not go the route of juries in the state of Israel. Okay. According to Rosenberg in his article, the biggest problem is wrongful acquittal because of sympathy with the defendant, right? So here we have this notion of not of jurors who are not necessarily passing the law based on the facts or based on the law, but based on their own personal sympathies, which hopefully are less extent when it comes to proper judges who are appointed based on their expertise and knowledge and piety of sorts. Okay. I think as well it's important to note in terms of the unanimity that's required of a jury, that's why we mentioned the cruel based-in that would not execute someone in even 70 years. Right? According to Jewish law, it's really hard to pass capital punishment. Right? The final thing we have here is a notion of sometimes we have a based-in that has to pass laws, and sometimes we have a based-in that is passing laws in order to be able to stop a crisis from happening. Even though we might not have all of the evidence in place, sometimes a judge needs to act in a certain way. So let's see the way the Shulchan Aruch puts it here in Choshen Mishpat, chapter 2, halacha 1. Kol beis din filim smich beis shalom roim sham prutim ba'averis. Any beit din, any court, if they see that the people are acting corruptly, improperly, donin ben misbein mammon ben kol dinei onesh. Afilo ein b'davar edus gemura. They can actually judge even without complete evidence. So although we say that you need evidence, proper evidence when it comes to a based-in, there is a lot of power that's invested in the dayanim and in those making the judgments. And if it's somebody who is a threat to the community, you can even pass them off to the authorities to deal with. As long as all of the actions of the Dayanim are for the sake of heaven. So we have a notion as well in terms of who is sitting in the basin. It's just not just about knowledge, but it's also about piety. Now, the reason that I bring this particular paragraph is because we see that it can be two categories of judge. Either it can be someone who is Gedolei Ador, the great leaders of the generation in terms of the great rabbis, or it can be appointees by the community, right? So they may or may not, they could be very prominent laypersons, which is almost akin to our jury, not necessarily people who are the great experts in the law, because what we're looking for here sometimes is people who are going to be able to enforce justice, not only people who are going to be expert in the law. It says, and that's our custom everywhere, that the leaders of the city, right, maybe lay leaders of the city, are considered like the high court in Jerusalem that we had of yore. And they can give lashes to people and give punishments for hefker and hefker, and they can take people's property. Kafia minhag, according to the norms and practices of the place. Some people disagree and they say, no, the task of the leaders of the community are just to chastise people, exhort people, admonish the people. B'mashi minhag mekedem shekil aleim b'das kolam, aval en rishon l'shanos lishnos dov mided ikar ravcha lahai v'psed lahai. At the same time, though, they can't advantage one party and disadvantage another party, or to remove money from one party and give it to another party unless it is for good reason. And nevertheless, we follow the custom of the city. And how much more so if the community did accept their authority upon them, then they would be accepted for all matters. So we know at various times throughout our history, as recently as the Vad Abba Aratzos, the Council of the Four Lands in Eastern Europe, we had a certain autonomy. We had legal autonomy for our community, and justice was carried out by the leaders of the community, some of whom were rabbis, some of whom were not rabbis, some of whom were experts, some of whom were there simply to carry out justice. Another example we find in the travelogues of Benjamin Tudela, who talks about, we're talking the Middle Ages, he visits Yemen and he sees the Beis Din that carries out capital punishment there. So as long as it is that the community has accepted the system of law, then there doesn't necessarily need to be a one way of doing things and not another way of doing things. The main thing is that the community has accepted that these are the norms and practices legally of the community. So based on that, it would seem that one should absolutely serve on a jury in order to support the notion of din d'malchus adina, that the law of the land is the law. And we support the Noahide law of establishing systems of justice, and we have to be role models for that. And even though it may seem that these jurors may not be experts in the law, we certainly have a precedent. We have halacha that tells us traditionally that it doesn't matter whether or not they are experts, as long as you have somebody in the room that's the expert, and that would presumably be the judge. The others who are there are allowed to be there to offer their thoughts and be able to adjudicate based on the facts that they see. Thank you all for tuning in this evening. For those who want to catch the shir live in person, it will take place on Shabbat after Mincha. Wishing everybody a fabulous week. All the very best.